We know it's early. But what better way to start your day than by getting free legal advice? This is Vastola on the Law with your host, attorney Jeff Vastola, featuring 30 minutes of free legal advice. Call in now with your questions. 877-850-8585. That's 877-850-8585. Now here's your host, attorney Jeff Vastola.
Good morning, everybody, and thank you so much for tuning in. My apologies for last week. I had some technical difficulties on my end that kept me from being live on the show with you, so I do apologize for the replay, but I am live at the mic today. My name is Jeff Vastola, and I'm your host. I am an attorney, and I'm here to give you free legal advice for the next 27 minutes or so. If you'd like to call into the show, the number to call into the show is 877-850-8585. If you'd like to talk to me after the show, the number to call is 833-VASTOLA, spelled just like my last name, obviously. That's 833-827-8652. So, the 877 number is good from 7:30 to 8 on Saturday mornings to reach me. The 833-VASTOLA number is good 24/7. If I don't answer the phone, leave me a message and I will call you back. Well, good morning, everybody. Thank you so much for tuning in. It is February 1st, 2020. Welcome to February. And I am here to talk today about Florida's comparative negligence laws. I know, stimulating. But the reason I've decided that this will be my topic for the day is because I'm going to travel to Jacksonville on Monday to take the depositions of several FHP officers who were involved in the investigation of a really awful crash, and the conclusions of the report were somewhat missed the mark, so to speak. So I want to talk to you all today about the difference between contributory fault and comparative fault. Some might say, well, that's semantics. They mean the same thing. Well, in the eyes of the law, they are two completely different concepts, and the applications can make the difference between having a case and not having a case. So that's why I've decided to talk about this today. But of course, I always give priority to those people that call into the show with questions of their own. If you have a topic today, now listen, I'm a personal injury lawyer. I do injury claims, wrongful death claims, product liability claims, medical malpractice claims, but that doesn't mean that those are the only things that you can call me about. This show is wide open to call me about anything that you want. If you ask me a question and I know the answer, great. I'll give you the answer, and it's free. If I don't know the answer to your question because you call me and you ask me about family law or bankruptcy or criminal law, then I'll do the research that I have to do, and then I'll give you an educated response to the question the following week on the show. And as a plus, if you happen to miss a show, you can always go back to the library and listen to the show whenever you want. I'm not a huge podcast guy. I've never really gotten into listening to things that are recorded or provided via audio over the web. But I recently went to my show page, and you can find my show page on the WFTL website. You just type in 850 WFTL, and Google will quickly find the WFTL station website. And if you go to my show page, which is somewhat hard to find, but it's there, I promise, you will see that there's a complete library of all of the shows that I've done so far on 850 AM. And just last week, I just clicked on one just to see what it would sound like and, you know, how does this actually work? And it was kind of neat. With all humility, it was really kind of neat to listen to the show as it was recorded. So anyway, the point is, if you ask me a question and I need to research the issue and I get back to you the following week, but you missed that week's show, you can always go to the library to pull it up. We save the shows by date and by topic, so hopefully you'd be able to find it, and there you go. That's the way it works, and I do not send you a bill. This is free legal advice. So spread the word. Make sure your friends and your family know that this is the place to go for free legal advice. And as I mentioned, what I do Monday through Friday, and oftentimes on the weekends as well, is I represent plaintiffs. I represent people that have been injured, or those representing the estate of those that have been killed for any kind of an incident that could cause the injury or the wrongful death. And so if you think that you have a case I'd be interested in discussing with you, that's why I give you the 833 Vastola number. Use it whenever you want. You can call me at night. You can call me on the weekend. And emphasize if you're somewhere and something has happened where you feel like, oh my gosh, I don't really know what to do. This is a legal issue and I'm not sure what to do. Call the number. Call 833 Vastola, because if I can answer the phone, I will. That number is forwarded to my cell phone. And you have immediate access to a lawyer to at least ask questions. If it's an emergency of some kind and it's an area of law that I don't practice, then I would put you in touch immediately with somebody that I trust. So that's why it's there. I just try to be a resource for everybody. And if you have any questions about me and who I am and my firm, go to vastolalegal.com. That's our website. About to be revamped, by the way. Very proud of that. Vastolalegal.com is our website address. We have a website up now, but hopefully in the next, I would say probably 2 months, we should have a brand new website for you. It's going to be much more user-friendly on the back end for me, so that I can do a lot of blogging and social media interaction and stuff like that. So I'm just trying to keep up with the times. I hate to admit that I'm a dinosaur, but when it comes to social media, I really am. If you'd like to call into the show, the number is 877-850-8585. Don't wait for a decent time, because it sounds like I'm going to slow down. If you wait till the end of the show, we may not have enough time to talk. And I'm going to keep talking all the way up to the end. So please interrupt me and make that phone call, because my preference is that I get to talk to people that call in. If you were wondering, what do I really prefer? Would I rather just sit here and give a lecture? Or alternatively, do I prefer the phone calls that come in? I will tell you hands down, I prefer the phone calls. So I always give priority to them. But in the meantime, because it's been slow and not everybody wants to pick up the phone at 7:30 on a Saturday morning and ask me questions, I have topics prepared. All right, so let's jump into it, okay? Now, this topic today is in the context of a car accident. And so it can be applicable in perhaps other aspects, but just so you understand, that's really the focus of today's discussion, is in the context of a car accident. And the concept of comparative negligence is a very broad concept that can be applied in any negligence action, theoretically. The case I'm going to focus on talks about a presumption of negligence that attaches in a rear-end automobile accident. And so I'm going to talk about the presumption. I'm going to talk about the case that's clarified issues for us recently. I'm going to talk about the seminal case that started all of this. And I'm going to talk about when did Florida decide to go with the concept of comparative. I'm sorry, one more time, Elliot? Perfect. Thank you, Elliot. We've got David from Delray on line 1. Let's take the call.
Yes,
Are you there?
I wanted to know, I have a thing, like, if somebody wanted to they had Parkinson's or MS, I found that it's brain sugar that was the problem. The procedure to let the sugar from the body flow to the brain regularly, it would be a surgery. How could if I get a patent for it, how would it be able to be enforced that I could get a percentage for each of these type of surgeries? It would be for, like, say, Parkinson's, MS, and epileptic seizures, because the problem is they're lacking in brain sugar. Something happened and the sugar is not going into the brain. This would be like a thing that would keep a certain part of the brain open so the blood can flow thoroughly through, and it would alleviate.
All right, well, don't give away too many of your secrets before you've got your
I'm just saying it would just alleviate the problems. How would I
David,
be able to? Do you do anything with patents?
I don't. I'm not a patent lawyer. As it's interesting though, because
how would
I'm
it
using
be
a patent
enforced?
lawyer.
If I go and patent it, if I go to the patent office and patent, how would I be able to enforce it? Because anybody could just read up on the new whatever new technology there is, and then because you have to display everything, how to do it. How would I be able to enforce it? That
Well,
I would get
here's, and this is going to seem like a punt on my part, but I'll research some patent issues and I'll get back to you next week on the specifics of how to go about getting a patent. But I'm strong to talk to a patent lawyer
and
because
can I ask you something
some
else? There's
things.
also another thing I found
Hey
out.
David, time out. David, time out. You got to let me talk. So let me just, because it's not just for your benefit, it's for the benefit of other people that are listening. Some things can be patented and some things cannot be. So the very first thing that you need to do is find out if your concept is something that can be patented, because otherwise you're going to spend a lot of time and a lot of energy trying to get a patent on something that you were never going to be able to patent in the first place. Okay? So now, if you're resourceful and intelligent, you can go to the USPTO's website and you can do your own research on existing patents to find out, first of all, is it already out there? And secondly, and probably more importantly, if it's already out there, are you going to be infringing on somebody else's patent because somebody beat you to it? Okay, so those are things that you either need to do yourself or you need to go see a patent lawyer. So a patent lawyer or their staff will do the search for you. But I know this, it's pretty near and dear to my heart because I have an invention of my own that we are in the process of getting a patent for, and I'm using a patent lawyer. Okay, so just so you understand how important it is, in my opinion, that you get one. I'm a lawyer, and I've been a lawyer for over 23 years, but I've decided I need the expertise of a patent lawyer to protect my interests. So David, that's why I'm recommending to you very strongly that if you feel as though you've got a good idea, protect it by using a patent lawyer, okay? Okay, David, now it's your turn.
Yeah. Also, there's something that exists today that checks out for viruses that morph into DNA codes. So that would still be in the patents? They already have the device, but they never even thought of using it this way.
Well, that's another issue for a patent lawyer because there's different ways to patent. There's different ways to patent things.
Yeah, because the gadget's already out there, but I mean, it's with me saying they could be used for these other ways too. That thing.
Right. Well, in those situations, you're typically going to have to give credit where credit is due, so to speak, and perhaps share in royalties with an existing patent owner.
Yeah.
But
you know, look, for that. Yeah.
I'm way out of my own ball field here talking about patent and trademark. It's such a specialized field that when it comes to patents, it's the only area of law where the Florida bar requires that if you are going to be a patent lawyer, specifically patent, now I'm not talking about trademark, I'm not talking about copyright, but if you're going to be a patent lawyer, you also have to be an engineer. So it is the only area of law that requires another specialized degree in order to practice in that field. So it's really interesting, very intellectual, but those are my 2 cents. Those are what I can give you here on 30 minutes of free legal advice. But David, I will research the issues to give you a better response.
Where would I
tell
find
you what
one in
types of things
Delray
are
Beach?
patentable, and what types of things are not.
I can't use you. Then how would I find one in Delray Beach? Just go to the library and find out?
Are you talking about searching the USPTO, Patent and Trademark Office, or are you talking about looking for a lawyer?
Bible and that.
I'm sorry, Dave. We keep talking over each other. Are you asking me how to find a lawyer?
Yeah, I'd like to know how's the best way to find one in that field, and then see if the thing is viable enough. Like you said, doesn't have any prior. People have priorly doing it. The lawyer will probably look for me, right?
Yeah, they can. I think the answer to the first question is, and most people would agree, word-of-mouth recommendations, I feel, personally, are always best. And then, secondly, once you've connected with a lawyer that you trust, you can direct those questions to a lawyer to say, is this patentable? This patent already exists, but I want to use it for a different reason. Can I do that? And if you want to pay the lawyer to do the patent search for you, they're happy to do it.
Probably.
Believe me. But if you want to do it on your own,
any
which is
idea
what
how
I
much
did,
that comes around? I'm right now. I'm like working part time. I'm handicapped, so I can't really do full time work. So I wanted to get an idea how much. Any idea the price ranges? Because you said you got a lawyer like that. Any idea the price ranges?
A very, very, very basic patent application submission. This is not including the search time to make sure that the idea is not already out there. I think the very, very basic patent application was around $2,500, if not, it was somewhere between $2,500 and $5,000, just to have paperwork filled out and submitted to the USPTO. So that should give you some framework.
So it's basically not cheap just to put it out.
No, they're not cheap. They're not cheap. And as a matter of fact, when I was talking with my attorney about it, he said, on average, when you throw in everything, a typical patent application runs around $10,000.
Oh, shit.
So,
okay.
now I don't know if that's expensive. I don't know
gotta
if that's
just
cheap.
keep that in mind. So I gotta find out these things.
All right, so listen up, David. I will give you some more input next week. Just tune in. If you missed the show, you can always listen to it via the library on my show page. And thanks for calling in, okay? I appreciate it. All right, thanks, Elliot. Let me know if anybody else calls in. I appreciate that phone call, though. As I mentioned, I do prefer phone calls over my topics planned for the day. As I mentioned, I'm going to jump into my topic. But if you'd like to be my second caller of the day, the number is 877-850-8585. That's the number to call into the show. And until I get another caller, I wanted to jump into this topic of contributory negligence versus comparative negligence. Now, let me just give you the difference. In a state that has adopted contributory fault, what that means is if the plaintiff, the person that's filed the lawsuit, the person that's seeking money for injuries, is more than 50% at fault for the accident, then they don't get to recover anything at all. Their claim is completely barred. If you had filed the lawsuit, it would get thrown out. All right, that's a contributory fault state. They've decided that if you are more than 50% at fault for the accident, then you don't get to recover anything. That's a pretty harsh position to take, in my opinion. Now, I represent the plaintiff. I understand if you're on the defense side of things, you'd say, well, it sounds good to me. The alternative concept is what's called comparative fault. Now, comparative fault states if the plaintiff does have some fault for the accident, and it doesn't matter how much, the plaintiff could have 80% fault, then the case will survive, goes in front of a jury, and it's the jury, typically, if you're using a jury, especially in an automobile accident type of scenario, it's the jury that will allocate the percentage of fault among all of those that are involved, including non-parties. You can have non-parties on the verdict form. They're called a Fabre defendant, Fabre being from the old case of Fabre versus Marin. And the jury gets to decide, okay, how much fault does the defendant have? That's the person that's been sued. The plaintiff is alleging that person's at fault and that person or the insurance company has to pay me. But also, if the defendant says to the jury, well, I think the plaintiff is at fault, and I also think that, Tom Jones over here is also at fault because, he did this, but he's not even in the lawsuit, the jury on the verdict form will specify the individual or the entity and specifically that percentage of fault. Okay, so you can have a plaintiff with 80, 90, 95, 99% fault and still recover because the plaintiff can recover that 1% that is owed by somebody else. Now, as long as that other person is the defendant. Because if the plaintiff is told by a jury that the only other percentage of fault is a non-party that hasn't been sued, well, you haven't sued that entity and therefore you're not going to collect any money. But let's just make it simple. Let's say it's plaintiff versus defendant and that's it. There's no non-parties. And the defendant says to the jury, well, I want you to allocate the comparative negligence of the jury. I'm sorry, jury. I want you to allocate the comparative negligence of the plaintiff. The jury can come back and say, okay, we think the plaintiff was 80% at fault. We think the defendant was 20% at fault. And we're going to give the plaintiff $1 million. Well, what that means is $800,000 of that million, which is 80%, goes away because the plaintiff does not recover for his or her own negligence. The only thing the plaintiff would recover in the example I've just given you is $200,000 for the 20% negligence that the jury has allocated to the defendant. That is, in its simplistic form, how comparative negligence works in the state of Florida as opposed to a contributory fault state. If this example were given to you in a contributory fault state because the plaintiff was 80% at fault, meaning clearly more than 50%, the entire case gets thrown out and the plaintiff wouldn't get to recover that 20% allocated to the defendant. So, a little bit of history. Back in 1973, the Florida Supreme Court decided the case of Hoffman versus Jones. And that is the first time that the Florida Supreme Court specified that Florida was going to go forward under a comparative negligence concept. And of course, the court highlights all these various reasons why it is the more fair way to proceed. But since 1973, with this decision in Hoffman versus Jones, Florida has proceeded under comparative negligence. And then what happened was, there's been a lot of cases since then. But the reason I'm going to talk about this case of Burge versus Charon, which is another Florida Supreme Court case from 2012, so we're talking much more recent, is because as time goes on, new fact patterns come along from different cases that are appealed, and these new fact patterns create new questions for the upper courts to decide, okay, well, is it applicable here or perhaps not over here? And then over time, what happened is Florida's jurisprudence, which are those decisions rendered by the judges in the state, determined that there is what's called a rebuttable presumption for the negligence of a driver that strikes somebody from the rear while operating a motor vehicle. Okay, so there is a presumption that the driver that hits somebody from behind is negligent. So if you're sitting at a red light minding your own business and you get struck from behind by somebody that's on their cell phone or not paying attention, then you have a really, really good case. You not just have a good case because you weren't doing anything wrong. You have a good case because there's already a presumption of negligence on the other driver. And the liability of the other driver is oftentimes a major determining factor as to whether you have a good case or not. So over time, though, once the presumption of negligence came about, it started to get eroded a little bit because now it was determined that it was a rebuttable presumption of negligence, meaning, well, hold on a second, what if? All of a sudden, these what ifs started coming into the appellate courts. This fact pattern is a little bit different. All of a sudden, hey, the driver in the front took a very erratic position or did something very erratic, and the driver from behind wasn't expecting it. And most often it's seen as a change of lanes or sudden braking where you would not expect sudden braking. It's stuff like that, where all of a sudden these appellate courts are being faced with these different fact patterns, and the appellate court starts to scratch its head and say, well, wait a minute. I mean, geez, there's a presumption of negligence on the rear driver, but yeah, what happens if the vehicle in front cut that person off? So in essence, the driver in the rear wasn't doing anything wrong. It's the driver in front that's negligent, yet we have this presumption of negligence, and that's not fair. Well, that's why all of a sudden it became a rebuttable presumption of negligence, and all of a sudden now you can present your facts to the judge and then ultimately a jury if you can survive a motion for summary judgment. And I'm almost out of time. And you can allow the judge, if it's a question of law, or a jury if it's a question of fact, to decide whether the presumption of negligence is going to go forward in the trial, or whether or not it's been rebutted, and then, of course, let the jury do its thing. Well, listen, I'm out of time. David, I want to thank you for your phone call. I'm going to do some research on patents for you, and specifically the questions you asked. And if anybody would like to talk to me about a case, if you have a case, if you've been turned down by other lawyers, but in your gut you feel like you've got a case, please call me. I always encourage people to call me because I'm always willing to give cases a second look. There have been times in the past when I have not been the first person to look at a case. Sometimes I'm the third or fourth, and I've been able to find a basis for the claim. If you'd like to talk to me, the number is 833-VASTOLA. That's 833-827-8652. And I'm available anytime that number goes to my cell phone. If I do not answer my phone, leave me a message and I will call you back. So, thank you so much for spending time with me. Thank you, Elliot, for your excellent work on the board. I appreciate that. And until next week, do the right thing.
About the law and the law one. About the law and the...
You've been listening to Vastola on the Law with attorney Jeff Vastola. Tune in next week for more legal advice and answers to your specific questions. You can call Jeff on his cell phone after the show by dialing 833-VASTOLA. That's 833-827-8652.